I want to make sure everyone understands what we're talking about. So someone comes to Illinois, they go to court, they file a piece of paper to change their name, but it doesn't end there. It's actually a two-step process. The first process, the judge authorizing the name change, but then it's sealed, meaning it's not available to the public. Well, why would you do that? But it gets worse, and this is the part that people need to understand when you hear the pushback. The part that gets worse is it's a self-attestation deal. Okay, what does that mean? It means that all you have to do is sign it saying it's true, and that's it. It ends the inquiry. There's no judge asking about the veracity, inquiring into the veracity of that statement. There's no documentation that's required to be attached to prove, that you're here lawfully. None of that, which, by the way, you could have put in the bill, but they didn't put that into the bill. So instead, you have something that's going to allow you to change your name, have it sealed by a judge on a self-authenticating simple signature. No inquiry, no documents, nothing. This is kind of like, and I was thinking about this, somebody mentioned, you wouldn't go enter into a will without having witnesses there to the signatory of the will. But, I actually thought about something even worse. Like, what about, think about it this way. If you had someone on their deathbed changes their entire will, and instead of giving their inheritance to their children, suddenly gives it to the gardener on their deathbed. You wouldn't allow that without a witness, without an authentication, without some sort of verification. Nobody in their right mind would do that. But that's what we're doing here. We're allowing people on a simple signal signature to self-authenticate this document, no inquiry, no nothing. And you could have added those things to this bill to make it legitimate, but they didn't, which makes it illegitimate.